Hello, today I'm going to talk to you about a decision of the High Court in England and Wales in July 2019 called Broadsheet, and it pertains to a challenge of an arbitration award under Section 68(2)(d) of the UK Arbitration Act. And this is pertinent whenever you have an arbitration decision where the seat is the United Kingdom or England and Wales. Now, this particular issue was one of construction, of statutory construction. So in section 68(2)(d) says that in effect you can only challenge an award where something seriously irregular has occurred during the proceedings or in relation to the award itself, and this has to have some substantive significant prejudice on the party that's been affected. So you have a two-limb effectively test, and that makes it very hard for someone to overcome those limbs in order to bring a challenge. The particular question in Broadsheet was whether an award that is not sufficiently reasoned or insufficiently reasoned would mean that the award would fall foul of section 68(2)(d), i.e. An insufficiently reasoned award is a serious irregularity for the purposes of set aside under section 68(2)(d). And the court held it wasn't, and it reviewed a lot of the case law, particularly Compton, on the point, and found that actually this was another example of a party trying to fob the court off and not pay the award. One of the interesting cases that was cited in that is Margolede, and Margolede is a good one to discuss because it's relatively crystal clear in terms of the issues that were there before the High Court in another set-aside application under Section 68. Now, the points that were taken in Margolede were twofold. Firstly, that the arbitrators had failed to deal with a defence of mutual mistake in light of the fact that that defence could have little standing when one party is actively elected a contract, and there was evidence that the contract had been elected. Therefore, there could be no contractual defence of mutual mistake. And the other point that was taken was that there wasn't an opportunity given to respond to a submission by one party when that submission was made at the close of arbitration proceedings. Now, as to that point, that was just knocked out very quickly by the court in Margolede because every single little pinickety procedural unfairness or supposedly not giving you every opportunity is not going to undermine an entire arbitration award. Otherwise, we'll have challenges coming left, right and centre and totally destroying the whole idea behind the Arbitration Act of empowering arbitration. In terms of the other challenge, the one that there wasn't adequate reasons or sufficient reasons given, on the point about mutual mistake, the court found in Margolede that the fact that the arbitrators didn't expressly deal with that point did not mean that that was going to be an irregularity that would engage Section 68, subsection 2D. So, because the court had fundamentally dealt with the issues before it, so the arbitration panel had dealt with the issues before it, it had dealt with the issue of mutual mistake in its reasoning and had come to a conclusion that was otherwise fair, that this small point of not directly going on about this particular issue in depth would not mean that the award would be set aside. And that's quite important, again, from the point of empowering the arbitration system to have a certain amount of integrity so it can get on without worrying about challenges left, right and centre, and also making sure that arbitration awards are enforceable. Now, I was particularly curious about this because I was very lucky 10 years ago to work with Mr. Justice Coleman, who had sat on many of these challenges before he retired in the High Court. And Mr. Justice Coleman and I worked on a lecture that he gave back in 2007. And he made it clear to me that it was very, very difficult to bring challenges under the Arbitration Act to challenge an award. And we know, for example, from his judgment in Zarnicow sugar that little defects in arbitration awards, little lapses in logic, or sort of lack of full explanations in arbitration awards don't mean that the arbitration award is rendered nugatory. In fact, the Arbitration Act also is designed in such a way to actually allow for a considerable amount of rectification of an award before those challenges could even be engaged. So, for example, under Section 70 of the Arbitration Act, the arbitrators themselves can rectify an award. One of the parties can ask the arbitrator to rectify an award. And, of course, under the Act, we also have the court having the power to rectify an award or to expand upon it. So the court can ask the arbitrators to rectify part of the award or expand on a particular part of it before any challenges are brought, so as to minimise disruption to the finality of the award and ensure that award has effectively the rule of law behind it in terms of enforcing contract law. Because ultimately, of course, arbitration awards stem from the consent of the parties in the contract.